Car accident injury claim. Should I settle or go to court? Hi, I'm attorney John Sheehan. Since 1993, I've represented thousands of injured workers and car accident victims throughout Massachusetts. Well, let me answer that question, whether you should settle or go to court, as many lawyers answer questions. It all depends, and it truly does. First of all, you have to look at how much available coverage is there. How much coverage does the at-fault or negligent driver have in their insurance policy? If it's only what we call a 20-40 policy, that means that the most that's available is $20,000, and the insurance adjuster is offering the full policy limits, and the defendant doesn't have any assets available that would pay you compensation not covered by his car insurance policy, then you absolutely should settle and not go to court, because there's nothing you can get from that defendant. The defendant is what we call judgment proof. The other thing you need to look at is the strength of the case. Let me explain that in any personal injury case resulting from a car accident, there's two parts to the case: liability and damages. Liability in a car accident case has to do with negligence. Who was at fault? Whose fault caused the accident? Whose negligence caused the accident? So you look at what the strengths are to prove that the accident was caused by the other driver. But damages is the second part of the case. Damages include both economic and non-economic damages, or they're also referred to as special damages and general damages. Economic and special damages are easy. Those are things that you can add up. They're quantifiable. Things like your medical bills, lost wages. You can just add them up, see what they are. You have the documentation to prove the amount, and those are your special or economic damages. General damages would include pain and suffering, loss of impairment that's been documented by either your treating doctor or another doctor that's evaluated you, and maybe loss of enjoyment of life, loss of things that you used to do. Maybe you were very physically active and you were involved in sports, and now you can't play the sports. In deciding whether or not you should settle or go to court, one thing you need to consider is how far apart your attorney is and the insurance adjuster is with the settlement negotiations. If you're very far apart, then you might have to file a lawsuit. Filing a lawsuit does not mean that you're not going to continue to negotiate. And oftentimes, when you file a lawsuit, the claim would be assigned to another adjuster with more experience. And usually one of the first things a new adjuster will do is to try and go back and revisit with the personal injury lawyer to see if there's a chance to resurrect settlement negotiations, and maybe lo and behold there's more settlement authority available, more money to offer, that the other adjuster was holding back. The other thing to consider whether or not to settle or go to court are alternatives to going to court, alternatives to going to trial, alternative dispute resolution, and that can include arbitration. It can include a high-low arbitration where you do an arbitration but your attorney and the insurance company agree on a maximum and minimum amount that you'll receive depending on what happens at the arbitration, so you're at least guaranteed a minimum, and the insurance company has some protection as far as the maximum they'd have to pay. Another popular type of alternative dispute resolution that I'm a big fan of is mediation. Mediation is basically a settlement conference with a professional mediator, either an attorney with a lot of experience, a lot of years of experience handling car accident, personal injury cases, perhaps on behalf of insurance companies, or perhaps representing car accident victims, or has done both. Or also, many times mediators can be retired judges who've sat on trials, who've sat on the bench, who have seen litigants present their case, have seen what juries do, and can offer that perspective to the parties, offer that perspective to the accident victim, the plaintiff, to be able to assist them to reach the best decision at a mediation as far as settling a case. Another thing you need to look at is, are there any problems with the claim? Is there any pre-existing injuries or medical conditions that the insurance company would point to in saying that that wasn't caused by the car accident? Or if the medical records do show that there was some worsening of the pre-existing condition or pre-existing injury, that at a certain point in time the plaintiff returned back to the same position they were in before the car accident. Another thing to consider, apart from prior accidents or injuries, are there other previous medical conditions or degenerative conditions such as arthritis or degenerative changes in the discs of the back, if it's a back injury case, that could put into question what's related to the car accident or what did the person have that pre-existed the car accident. And finally, another consideration or potential problem in considering whether or not to settle or go to court is, does the plaintiff have a history of prior claims, prior car accident claims? If you have a history of prior personal injury car accident claims, then there's a risk that that is going to get into evidence at trial and could affect the outcome of the trial. One of the other benefits of settling a car accident personal injury case is that you control the outcome. You know exactly what you're going to get, rather than going to trial and it's a gamble. Plus, if there are any healthcare liens, mass health liens, Medicare liens, perhaps there might be a short-term, a long-term disability lien. With settlement, your attorney has the ability to try and negotiate the best terms possible for you as far as reimbursing any lien for mass health, for child support, for short-term disability, things like that you wouldn't be able to do if you went to trial. You also have to consider the risks of going to trial. Again, it's a big unknown. You could lose. You could get less money than what's being offered. There are more expenses, much more expenses involved with going to trial for things like depositions, medical experts who might have to testify either via video deposition or in live testimony in court. That costs money. Also, think about the delay. You could wait up to 2, 3, or more years to have your day in court, to have a trial date. If you've been injured in a car accident in Massachusetts and you'd like to talk about your case with me directly, feel free to call or text me at the number below. And if you'd like to watch my future videos, please subscribe to my YouTube channel.